Good evening to the participants of the JCJ main examination, which is going to be held on 26 November 2022 if it is not postponed. In my yesterday class, we are dealing about the section 151 of the CPC, and which is nothing but the inherent power of the courts. Yes, welcome Ausia to the class, and we are dealing about the inherent powers of the court under section 151 of the CPC. Now I posted on the screen, and can you read that what I posted on the screen? Ausia, could you read what I posted on the screen? Participants, are you hearing me?
Yes, sir. Section 151 of Civil Procedure. Welcome to the aspirants of JCJ 2022 main examination online class on 7-11-2022. Section 151 of Civil Procedure Code deals with the inherent powers of the court, ends of justice, abuse of process of the court, limitation. Professor Dr. Mohammed Saheb Hussain, Professor of Law, School of Law, Sought Mazwa Manzwa,
Mwanza,
Tanzania, East Africa. Monza.
Tanzania,
Yes.
East Africa. Okay, now without wasting the time, let me go to the inherent powers. What are they and how it can be made it out? These inherent powers a court can deal even though the law is silent, because the court cannot wait for the law amendment should be made, and the court also see that there will not be a abuse of the power, limit to limit the abuse of the methods of the court. So it is not obligatory for the court to wait for the law made by the parliament or order from the higher judiciary. Court has a discretionary or inherent powers to make such an order which is not given in terms of the law for the security of the justice or to check the misuse of the methods of the court. So when there is a something goes wrong over there, even the law is silent, even the law they could not wait it, the law could be made over there. At the time the court will make the inherent powers under section 151 of the CPC. Now let us see the scope of exercising of this section 151 of the CPC can be represented by some cases which are as follows. From here we have to delete because I put the asterisk over there in my last class. Last class is the means it is a Saturday it is held, and yesterday was the Sunday, the public holiday, so I would like to give the time to them to spend with their families, and the family also more important to them. Okay, but now let us, without wasting the time, the first bullet says the court may recheck its orders and resolve errors. In case the court has given an order earlier, so it can recheck it, the order, and resolve if there is an error will be there. So it is a power given to the inherent power under section 151 of the CPC. Second bullet is issuance of the provisional sanctions when the case is not included by order 39. Generally the order 39 should be included over there, or to place the alongside the ex parte order, or to place an ex parte order also. When such a situation arises over there, it could have the inherent power. Number one, illegal orders or orders passed without jurisdiction can be set aside. Yes, if any order is passed illegally or with a fraud, then we cannot say it's a conclusive judgment, or orders passed without jurisdiction, and that can be set aside. 2. Subsequent events in the case can be taken into consideration by the court. If the subsequent event is taken by the court and for the consideration which is genuine, okay, it will be allowed. If not, it can be set aside. Power of the court to continue trial in camera. Yes, there is an inherent power. Okay, the second point is it goes like that. If a new thing has come over there, a subsequent a new thing is happened over there, which is a genuine, yes, it can be taken into consideration by the court. It's the inherent power. And the third, power of the court to continue trial if it is such a sensational case would be there in camera, or prevent disclosure of its proceedings. Which cases will be undertaken in camera? Participants? Sir, partition suits. Is it in the
No,
camera?
sir. No, sir.
I asked the plain question, which cases would be undertaken or trial will be continued in camera?
The cases relating to the modesty of the woman, rape by the, rape of small victim girl, like that, sir.
Any sensational
Sometimes,
cases, preferably,
sometimes family matters also, sir.
and if it is causes a bad impact on the society, a stigma on the society, we should not be discussed in the open court. Such cases should be undertaken in camera, like what you have given the example.
Yes,
And the
sir.
next fourth is the court can erase remarks made against the judge. In case if there is any remarks would be against a judge, the court having the inherent power to erase the remarks in the there. Then the last part is the court can improve the suit and rehear on merit or re-examine its order. If the court feels that it's committed certain mistake, or there is some lacuna would be there, or there would be a gap would be there of the law, then at the time the suit can rehear on merit or re-examine its order also. Even the re-examine its order, whether the order is properly delivered or not. So these are all comes under the inherent power of the court under section
151C, CPC,
151 of the CRPC, sorry, CPC.
CPC.
Ends of justice. What is meant by ends of justice? Let us see in the case of Devendranath versus Satya Baladas. Actually, it's a Devendranath because generally the B can be pronounced, the V can be pronounced as a B. In which area?
In Bengal.
In the
Bengal, sir.
Bengali area. It is the Rabindranath Tagore will say, but they say Rabindranath Tagore. Okay, that is Devendranath versus Satyabala Das. The meaning of ends of justice was explained. It was held that ends of justice are Salman words. Also, there is a words that are not merely a polite expression as per the jurisdiction methodology is concerned. These words also indicate that justice is the pursuit and end of all the law. However, this expression is not vague and indeterminate notion of justice according to the law of the land and statutes. What is meant by end of justice generally? Is the death of the justice?
No, sir. It's a result of justice.
If the result of justice, is it by following the law? Or
Yes, sir.
sometimes
Surely.
we can keep the law aside. To meet the end of justice, we deviate the law also. Am I right?
But in courts, it doesn't happen, sir.
What
They
is meant by
follow only
inherent
law.
code then? Inherent power, what is meant by inherent power? The court cannot wait, the law should be amended. So the court will interfere in the matter and see that the end of justice should be made to the party. Number one. Number two, to minimize the abuse of the methods in the court. Yes, they say they cannot wait for the law should be amended over there and on the merits of the case and to curb the illegal mode or suppression of justice to the parties or abuse of the power of the court to the court. They take some powers and give the judgments. Under the 151, just we read it from 1 to 5. If they feel the order is given wrong, they can rehear it and re-examine it also. So the court is allowed to exercise these inherent powers in case like to recheck its own order and correct its order error, to pass injunction in case not included by order 39. In case not included by order 39 and an ex parte order against the parties. So, for the end of the justice, they may deviate also. When not deviate exactly, when there is a law is silent. Deviation means the rule is there, but the going against the rule is deviation. Am I right?
Yes, sir.
Abuse of process of the court. In the abuse of the process of the court, Section 151 of the CPC provides for the exercise of the inherent powers to check the infringement of the process of the court. Abuse of the powers of the court which happens in unfairness to the party needs to get relief on the ground that the act of the court shall not prejudice anyone. When a party practices fraud on the court or on a party to a proceeding, the remedies have to be provided on the basis of inherent powers. So the abuse of the powers of the court means when there is a fraud made by the party and thinking to the justice should be made based on this fraud account of the proof. At the time, it is nothing but the abuse of the process of the court. The court may interfere it. The remedies have to be provided on the basis of inherent power, which by virtue of 151 of the CPC, the court got it. Then the words abuse. The word abuse is said to occur when a court uses a method in doing something that is never expected to do, is the perpetrator of the said abuse, and there is a failure of justice. If there is a perpetrator trying to interfere, you are there to see the judgment would be given in there based on the proof which has fraud, then it is nothing but the abuse of the process of the court. Then inherent power would be there, then rectify its own defect. The injustice done to the party must be given relief on the basis of the doctrine of actus curiae neminem gravabit. The act of the court shall prejudice no one. Even the court act, it should not be prejudiced to no one. So that is the maxim. It's a common law maxim. And the common law maxim generally will be used when the law is silent, when the law will not interpret. Common law. What is meant by common law?
The law used by the Britishers, sir, prior to independence.
Based on the various factors like the customs and usage and the permanency and the fair justice, and that is the common law. Then I used to say one statement on common law. Common law will not die. I repeat, common law will not die. Even though it dies, it rules from the grave. Repeat.
Common law will not die. Even though it die, it rules from the grave.
Yes. If it dies, it rules from the grave. That means it never died. So a party to a case will become the perpetrator of the abuse in cases when the said party does acts like the obtaining a benefit by functioning fraud on the court, or a party to the proceedings, prompting the multiplicity of the proceedings. At that time, the court will think it is abuse. They stifle the person perpetrated who is using such methods to getting the justice by producing the false documents or false evidences, or indulging in the party to the proceedings to get the judgment in their favor by producing the fraud documents or fraud or false witnesses. So that's why you can say. Section 152 of the CPC deals with the amendment of judgments, decrees and orders. 151 says inherent power of the court, and 152 says amendment to the judgments, decrees and orders. According to section 152 of the CPC, the court has the power to change either by own action or on the application of any other parties. Either by own action means, what is the terminology we can use it in the law? Can you say suo motu?
Per se.
Yes?
Yes, sir.
Good. So either by own action or on the application of any of the parties, written or arithmetical mistakes in judgment, like a calculations, like a subtraction, addition, multiplication, division, decrease, or orders, or fault, arising from an unexpected lapse or imperfections. So many other factors they have made it over there. At that instance, the judgment can be amended, the decree can be amended, and the order can be amended. Under section
152.
152 of the CPC. Now let us throw light on the section 153, deals with the general authority to amend. This section empowers the court to amend any fault or error in any proceedings, in suits, and all required improvements shall be made for the purpose of arranging the raised issues or depending on such proceedings. So this is a general authority to amend it in case of any fault or error in the proceedings, in the suit, they make it out. Section 152 and 153 of the CPs make it clear that court may correct any blunder in their experience at any time. In case the court has made any mistake or blunder, the court is having a power under this section by virtue of the section 152 and 153 to correct himself or herself. Court is feminine gender or masculine gender?
Feminine gender, sir.
Did you see anywhere?
No, sir. The court, justice symbol is lady with the covered eyes, sir. With
Yeah,
black cloth.
that is true. Does it mean that the court means a masculine gender? The court, her order, his order, did you see anywhere?
Its order.
Even I myself, I did not come across such a word. The courts in their own order, they say. But I did not see in her order and his order.
Yes, sir.
The court itself will say otherwise. Am I right?
Yes, sir.
Okay. Power to amend the decree or order where an appeal is summarily dismissed and place of the trial to be deemed to open court are defined under section 153A and 153B of CPC. So, if the court wants to change their own order or decree or the judgment, by virtue of the 152 and 153, it can done so under CPC. Is it clear?
Yes, sir.
Now, power to amend decree or order where an appeal is summarily dismissed and place of the trial to be deemed to be the open court are defined under the section 153 capital A and 153 capital B of the CPC 1998. Why they mentioned capital A and capital B?
They have amended subsequently, sir.
It is amended subsequently to the main provision. At that instant, they cannot make it the proviso or a clause directly. They added without having any punctuation mark to the number. Am I right?
Sir.
There should not be any punctuation like hyphen, comma, full stop, colon, etc. between 153 and A, between 153 and B. That's why 153 capital A and 153 capital B of the CPC 1998, they made certain amendment regarding the how to make the amendments when the case is summarily dismissed or trial to be deemed to be open court are defined. So these are the things made respectively under section 153 capital A and 153 capital B of the CPC 1998. So these are all regarding the amendments are concerned. 151 inherent powers, 152 amendments, 153 yes the amendments regarding the many other factor, 152 capital A, 153 capital A, 53 B, summarily it is dismissed or also in the deemed to be in the open court, even that thing also could be amended. Now limitation. Now let us see what is limitation. The exercise of inherent powers carries with it certain barriers, hindrances, impediments, and such as they can be applied only in the deficiency of particular provisions in the code. When there is a deficiency of a particular provisions in the code, then only this inherent power can be added. So that is the limitation. They cannot be applied in dispute with what has been expressly given in the code. If it is expressly given in the code, if there is no absurdity, there is no any false deviation at the time, they should follow the correct provision of the law. And literally they should follow it. They can be applied in rare or exceptional cases. While operating the powers, the court has to follow the method shown by the legislature. Court can neither exercise jurisdiction nor interest in them by law. Generally, people will not take these inherent powers. Do you know why? There may be possibility if they cross the limits, or if the expression or the code is very clear, if they use their own tactics to twist it, then they will be cut out. Am I right?
Yes,
They
sir.
don't want to take the trouble, isn't it? Suppose the party is not
Yes.
satisfied over there, let them go to the appeal. Am I right? But certain judges, they say, because they feel it is injustice to the party, at that instant, they will voluntarily, the suo moto, will interfere it and see that a justice should be done. Otherwise, their conscience will kill them. Their consciousness is, it will kill he or she or them. And that is a very important factor. So, courts can neither exercise jurisdiction nor interest in them by law. Of course, by law, it will not be interested. But when the deficiency in the provisions would be there at the time, the inherent powers could be used. To abide by the principle of res judicata is este, id este, not to open, that is, not to open the issues which have already been decided finally. When a finally decided issues are there, better not to touch it. If you touch it, it is touching a beehive. Did you get my point?
No, sir.
What is meant by beehive?
Pasan, sir.
Beehive means tene putta. Do you know honey?
Yes, sir. Yes, sir. I know, sir.
Tene puttanu beehive antaru. Spelling?
BEHAIVE.
Run. BEEHIVE. I will show you here. Did you see? Did you see on the screen?
Yes, sir. Yes, sir.
What is the spelling?
BEHIVE.
Professor Hussain students will not spell in that way.
BEEHIVE.
I appreciate. It is called beehive, isn't it?
Yes, sir.
So I told you once, if you miss my class, you miss many things. Am I boasting? Am I boasting?
No, sir.
Okay. So when the res judicata is there, when the case is already touched over there, please don't touch the beehive, we'll say. What will happen if you touch the beehive?
It will.
The bee stings you. That is called stings. So not to open the issue which have already been decided finally. To pick a mediator to make an award afresh, substantial rights of the party shall not be taken away. In case if you want to keep the mediator, but you will see that substantial, that rights will not be taken away. If a light modification would be there, you can make it out. To limit a party from the taking of proceedings in a court of law. See, these inherent powers give the limitation to the party not to take the law in their own hands and to set apart an order which was valid at the moment of its issuance. Yes, they can make it out when there is a clear throttling the justice neck or misuse of power made by the parties or a party which is interfering the proceedings by using the fraud means. At that instance, yes, they can interfere it, they can deal it. Those are the inherent powers and those are the limitations. So, limitations are must for man or woman or anyone. Am I right?
Yes, sir.
Sir, I am a professor, so I should not have a limitation. Answer is every person should have the limitation. And the limitation is for the growth. Please note the point. Limitation is for the growth of a person, not to throttle his, success. Okay, execution of judgment and decree. That is order 21. How a judgment will be executed and how the decree could be executed. Meaning, nature and scope. The term execution is not defined in the CPC. The term execution means implementing or enforcing or giving effect to an order or a judgment passed by the court of justice. In simple words, execution means the process of enforcing or giving effect to the decree or judgment of the court by compelling the judgment debtor to carry out the mandate of the decree or order and enable the decree holder to recover the thing granted to him by judgment. Sir, when the court has given an order or a decree or a judgment, then why it will not be implemented, sir? It should be implemented in total. Sir, because the court, that there is executive machinery deficiency would be there, sir. That's why the court will not make it out to see everything should be done. Again, you have to remind the court, sir, by filing the EP.
Execution petition.
Executive petition. That's why the civil suits will take longer time. If you file a suit, your grandson will eat the fruits. No, that should not be there because justice
It's
should
very
be done and it seems to be done. What is the use of it? If justice is made after 20 years, suppose if you are feeling thirsty now, you will be given the water to quench that thirst. If you are feeling hungry now, give some morsel of the food so that your hunger may be controlled or nullified. But what is the use of it after the 2 days later if it is given when the fellow is no more in the world? No more in the world. So here illustration we have given is X files a suit against Y for 20,000 and obtains a decree against him. Here X would be called the decree holder and Y is the judgment debtor. And the amount of rupees 20,000 is the judgment debt. So how many players, how many characters are here?
X and Y, sir.
There are 3 characters are there. Who are they? Number 1, decree holder. Number 2,
Judgment debtor.
number 3, judgment debt.
Court will be there.
The amount. Suppose the amount is not there, where is the question of judgment debtor and judgment or decree holder? సార్ అమ్మాయే లేదు ఇక పెళ్ళి ఎక్కడదండి if a girl is not there, if the bride is not there, where is the question of marriage? And there is no question of thinking about the baby also. So now the question comes, Y is bound to pay rupees 20,000 to X as the decree is passed against him. Suppose Y refuses to pay the decretal amount. The amount which is fixed over there is called decretal amount to X. X can recover the said amount by execution through the judicial process. That is called filing the executive petition. The principles governing the execution of a decree are order given in section 36 to section 74 substantial law and order 21 of the code, which provides for the procedure law. So order 21 is the very, very, very important order under CPC. Am I right?
Yes, sir.
Very good, very good. Execution proceedings under the CPC. Read the case law.
Yes, sir. In Ghanshyam Das versus Anant Kumar Sinha, the Supreme Court held that
Anant
the
Kumar
Supreme Court
Sinha.
Yes, sir. Anant Kumar Sinha, the Supreme Court dealt with the provisions of the code relating to the execution of orders and decree and stated that the code contains elaborate provisions which deal with all questions regarding executability of a decree in all aspects.
Yes. The case is there which is given Ghanshyam Das versus Anant Kumar Sinha. The apex court of the country, that is the Supreme Court, dealt with the provisions of the code relating to the execution orders and the decrees, stated that the code contains elaborate provisions which deal with all questions regarding the executability of the decree in all aspects. So very clearly it is mentioned under the code how a decree can be executed and what aspects should be covered. It is dealt in that case law. The court further observed that numerous provisions under Order 21 take care of the various situations, providing the effective remedies to judgment debtor, decree holder, and claimant objectors. In the cases where the provisions are not capable of giving the relief in adequate measures and in appropriate time to an aggrieved party, then filing a regular suit in the civil court is the solution. What will happen? If they are not going to get the remedy, even though after they get the decree or the order or the judgment, then the aggrieved party should have to file an executive petition in the court of law. In the same court or in the different court?
In the same court, sir.
Suppose if I file in the different court, do they admit it?
No, sir. They'll return it for filing in the appropriate court, sir.
They will ask you to file it in appropriate court in case you are at fault. Am I right?
Yes, sir.
The court further explained that the judicial quality of the remedy under Civil Procedure Code is considered to be the superior as compared to other statute thereof. Of course, it's a very good, but it should be done in no time. There would not be a delay in execution of a order or a decree or a judgment. It should be done as soon as it is adjudicated, the matter is adjudicated. The judges are expected to do better as they are interested with the administration of justice. So, justice will not to be done, justice seems to be done. Am I right?
Yes, sir.
When father, mother is alive, that fellow will not provide them the milk. But when they died, he has taken the sheep, buffalo, or a cow to the graveyard to give the milk to the grave. Is it the good way?
No, sir.
When you are alive, you take care of them. And don't admit them in the children's old age homes. Am I right?
Yes, sir.
If you do so, your children also do the same thing. Okay. Courts which can execute decrees. Yes, now I told you no, whether the same court or other court. Section 38 of the code states that a decree can be executed either by the court of the first instance or by the court which it has been sent for execution. Even that court has sent to the execution other court, okay, it can be done. Is it not?
Yes, sir.
But the filing of the EP should be the same court where it is disposed.
Sometimes it's sent for another court
Of course, on the direction of the court, they will transfer it.
or the subject matter is transferred to the sir.
Okay. In case if it is judged over there, later on the subject matter is transferred to the different court, they will ask them, okay, go to that court because the matter is now, this type of the matter is settling in that court.
Yes, sir.
So section 37 of the code further established the scope of the expression court which passed a decree with the object of enabling a decree holder to recover the fruits of the decree. The court which fall within the said expression are as follows. The first bullet says, the court of the first instance. What is meant by the court of first instance?
The court which passed the decree, sir. Original court.
The court which passed the original decree, the court where you filed the case.
Both are same, sir.
Okay, unless until you don't file the case, how the it will pass on?
Yes, sir.
First you sow, then you reap. If you don't sow, there is no question of reaping. So the court where you filed the case and the decree is disposed or order is given, first instance. And the second bullet is the court which actually passed the decree in case of appellate decrees. Okay. The court which actually passed the decree in case of appellate decrees. What is meant by this in case of appellate decrees? Suppose if it is appealed over there and the appellate court has passed the decree. Can you file in the first instance court or appellate court?
In the first instance court, sir.
Suppose the matter is reversed over there.
Even
The
though,
first
sir,
instance court passed the decree, but I appeal to the appellate court, and the appellate court is in the favor of it. When you want to the execution petition, could you file it in the appellate court or could you file it in the first instance court?
in the first instance court only, sir. The court, that appellate court will direct the first instance.
Appellate court may direct it even though it is passed the decree.
Yes, sir.
Which was reversed by the lower court, I mean first instance court.
Yes, sir.
See, any execution would be done in the first instance court only, where it is having the jurisdiction. The High Court will give the direction to the lower court to execute the order. Am I right?
Yes, sir.
Good. By this way, even in my life, I did not teach civil procedure code. But it is a disguised form of blessing to me. The court which has jurisdiction to try the suit at the time of execution, if the court is first instance ceased to exist, the court which at the time of execution had jurisdiction to try the suit, if the court of first instance has ceased to have jurisdiction to execute the decree. Suppose the first instance court is no more, and automatically the jurisdiction will be given to the other court. Am I right?
Yes, sir.
And that court will execute such a executive petition. So, explanation to the section clarifies that the court of the first instance shall have the jurisdiction to execute a decree, even in the case of any area being transferred from the jurisdiction of the court of first instance to the jurisdiction of any other court. Yes, as you said is right. Only the first instance court is having a jurisdiction to entertain such a execution petition, even though the matter is transferred to the other court. When
matter not transferred, sir. Matter was appealed.
Achha, matter is appealed to the other court. Okay. Suppose the cease to exist
चल यमुना गंगा उछल जलधि तरंग तव शुभ नाम जागे तब शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगल नायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।
ख्वाब तो सिर्फ कश्मीर की आज़ादी के आते हैं।